financial stability during divorce. So we're gonna start with some housekeeping stuff. So there's a disclaimer. Please note that the purpose of this series is to discuss general information on separation, divorce, and family law matters. Any information provided here should not be construed as legal advice. Also, please use the Q&A feature to submit your comments or questions. If you have questions regarding your specific matter, it would be best to call our office or a lawyer in your area to book a consultation to receive tailored advice. My suggestion would be one of the fine lawyers here, but that's just my suggestion.
You're not biased at all.
um, So if you stay tuned until the end, we will be sharing how you can schedule a free consultation, 20 minutes. It will be 20 minutes with one of our lawyers. So joining me today, as I said before, is Natalie Derbyshire and Golan Yaron. Hi guys, how are you?
Hi, Jodeen.
Great.
Thank you for having us. Hi, Natalie.
Yes, thank you for hosting. I'm so
Oh,
pleased to
wonderful.
be here with Mr. Yaron.
Yes,
Oh, come
yes.
on. What's the formality now? We know each other for a few years now. We just established that we know each other for 9 years. So,
It's true, we have some, sorry, no formalities, just friends.
So I'll just do a quick intro. These two seasoned lawyers who we have established are friends. So we have with us Golan Yaron. He is an associate family lawyer here at RIA and a certified mediator with over 25 years of legal experience. He was first called to the bar in Israel in 1996 and then called to the bar in Ontario in 2003. Golan has extensive experience representing clients and negotiating agreements, as well as trial work. He is also experienced in negotiating with authorities to advance a client's interest and has represented clients at various levels of court, including on appeals. We also have with us the lovely Natalie Derbyshire, and she was called.
Hello.
Hi. And she was bar of Ontario in 2006. She provides clients with peace of mind through sound legal advice and helps them navigate separation confidently. Focusing on dispute resolution processes like collaboration and mediation and negotiation, she aims to save clients money and serve her clients as well, and achieve reasonable settlements, specializing in supporting vulnerable clients, particularly those affected by family violence. Natalie offers legal knowledge, safety measures, and therapeutic resources. A certified collaborative practitioner since 2011, she serves on the board of directors for Collaborative Divorce Toronto and chairs its membership committee. She also serves on the board of directors for the Family Dispute Resolution Institution of Ontario. Wow. And co-chairs the family violence section. Wow, 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 wow.
definitely impressive,
Yeah, so
Thank you so
Natalie.
much, my friends.
thank you so much for being here with us. And so I think I will start off. Oh, I forgot to introduce myself. I'm Jodeen. I'm an article student here at RIA. I am not nearly as experienced as these two, but I am learning. I learned from their work and learned from all the other lawyers at the firm, and I'm very grateful to share the knowledge that I do have. And and I'm ready to learn more.
And I
So,
can attest that Jodeen is stellar and far too humble.
oh,
True
please.
that. Yeah.
I don't know how to receive compliments, so let's move on. Okay, so our first topic under today's major topic, which is how to maintain or gain financial stability during divorce, is assessing your financial standing. So it's my understanding that, it's one of the most important steps in securing your financial stability during divorce, because you need to understand where you stand, where your finances are. This means taking a clear look at your income, expenses, assets, and debts. Without this, it's difficult to make informed decisions. So, but if this feels overwhelming, that's where financial professionals and lawyers can come in to help. If you take an inventory of, your income, your expenses, your assets, your debt, it will help you in the negotiating process, because it's important to know where you stand. And also, you're going to have to share some of that information with the other party, should you enter into a collaborative agreement or a collaborative process, or if you're going into litigation. Financial disclosure is one of the most important things that I think people tend to overlook in family law, because they're hoping to keep some stuff hidden. Can't do that. So the next thing you want to do to start building financial independence is something like maybe setting up your own personal bank account if you don't already have one, and ensure that your income is deposited there. You also will like to organize your financial paperwork, make sure everything is together, because it will make things easier down the road. So beyond those immediate concerns, it's important to, set up a budget, emergency fund, those kinds of things. And if you have a prenup, you should or a marriage contract, you should review that with a lawyer. So we're going to get into a few more of those things as we move forward, because Natalie and Golan will be talking about that. Another thing that I think is important to mention is you will need to update your will and your beneficiaries. I think sometimes people don't think about that, because we're not really thinking about death most of the time. But in a divorce, a lot of things change, and your will and your beneficiaries need to reflect your current reality. So in short, assess your finances, ensure full disclosure, plan out what's next. If you take these steps, it can help give you some greater financial security. So, Natalie, a well-planned budget, I think we've established, is essential. But understanding your legal rights when it comes to, separating. Can you tell us a bit more about what that might entail?
Yeah, so as you mentioned, I do think it's important to create a divorce budget, not just a post-divorce budget, but a budget while you're actually going through separation. And if you don't have experience in paying household bills or balancing your checkbook or managing the financial affairs of the family, then you may wish to hire a financial planner to assist you in developing a budget. A certified divorce financial analyst may help you to identify your goals that you want to strive for in the future and concerns that you may wish to address post-separation. Early intervention is better, in my view, than hoping for the best. CDFAs, which is short for the Certified Divorce Financial Analyst I just mentioned, can show you how your current financial decisions can affect you on a long-term basis. Your financial health can very much be impacted by decisions you make today. and they can help you prepare for a termination of support obligations or entitlements in the future, as well as plan for retirement or saving for your children's post-secondary education. If you can't afford the help of a financial professional, then completing a sworn financial statement alone is a good exercise in helping you prepare a proposed budget. There is a section of the financial statement that deals with the proposed budget, and it can help you identify overspending, luxury expenses, and discriminate between wants and needs. Some of those wants can be cut out altogether by cross-referencing both your current budget and your proposed budget. And they can help you prepare for downsizing once you move into two separate households. Remember that the pie is now being split between two different households, so it's unlikely that you'll be able to afford the exact lifestyle that you became accustomed to during the cohabitation or marriage. Anticipate that your divorce will be costly. Plan for unforeseen expenses, and know that it's prudent to have an emergency fund or savings to plan for a rainy day. The other side may take steps outside of your control, for example, scheduling a motion, demanding questioning or interim disbursements, or the payment of expert fees. Support payments may also end up being higher or lower than what you think is reasonable, so it's best to consult with family law counsel. Take steps to be self-sufficient. Returning to school, upgrading credentials, or finding higher paying employment may be ways to increase your cash flow. Do what you can to maximize your income. Consult with your counsel to confirm if you're entitled to child support or spousal support, property division or equalization, and how much you can reasonably expect to receive. Also consider your borrowing options. You may wish to consult with family, friends, a mortgage broker, a loan specialist, or Bridgepoint Financing to help fund your overall legal fees in the family law matter. Finally, consult with counsel to make big purchases. It's always best to ensure that you ask for permission and not forgiveness. Consulting with your lawyer can save you incredible stress, time, money, and energy. Purchasing a home before your matter has concluded may not be in your interests. Many lending institutions require a fully signed separation agreement as a precondition to qualifying for mortgage financing.
Yeah,
Yeah,
let me
thank you,
touch.
Natalie. Yeah, go ahead,
Allow
Golan.
me to touch on both ends, both Jodeen and Natalie, speaking about all these important aspects of the finances. But I don't want it to be that it sounded like as if we're telling people to start stashing money away prior to separation or divorce. I think the idea that everybody has to understand is we want to ensure that there is no financial hardship or being taken advantage of because you don't have the finances to deal with the matter, whether it's legally or whether it's just your living expenses. If the situation does come to a complete separation or breakdown that is not amicable or is not reasonable in terms of how the budget is going to be split and how the finance is going to be flowing. So the idea, what we're trying to educate clients and people generally is you should have access to funds. That's the idea. Have access to funds, whether it's by credit card. Make sure that you have sufficient limit on your credit cards. Maybe you have a personal line of credit. But even, when you mentioned, Jodeen, that somebody can open their own account and maybe divert their funds to their salaries to that. The idea is not that you're not going to be responsible to share the information on that
Of
account.
course.
It
Yeah.
would be transparent sooner or later. The idea is that you'll have independent access to it. So it's not, if everything is just joint and all of a sudden the joint account is drained to zero and you have no credit card and you have no money in the joint account, and you only, maybe you have a job, maybe not, and maybe you just you have to live on that little bit, and maybe there are children involved that you need to care for. You don't want to be in that a financial position where you're just going to give in, because until we level the playing field, it might take some time. So what we're talking about is really a transition, a situation here that we want to make sure that the parties have their finances to consult, to deal with any legal matter if that comes up. We always, like Natalie said, that in the aspect of a collaborative or divorce financial planners, it really you're probably using that, Natalie, in your collaborative practice a lot. If when we introduce a financial planner, so it's not coming from either lawyer and it's more objectively viewed. And maybe that's the way to go, because we want to make sure that the parties are basically being educated if they have not had the experience in budgeting their own finances or looking after household expenses, etc. But the idea is to prevent that financial hardship, or making decisions that are based on a sort of financial abuse sometimes, right? Like the one party is using that excess fund to coerce or cause the other side to not have the ability to go through the proceedings or to get to a reasonable resolution, just because they're naturally not acting fairly, and they're not um, mindful of best interest of the children, the other side, etc. So the overall idea is that we hope that everyone would, even at the end of the relationship, would realize that firstly, if there are children involved, definitely want to make sure that their livelihood and their care is not affected by the situation. It's always going to be affected to some degree, but we want to make sure that it's minimized, and the same goes with the impact on the other partner, right? I mean, at the end of the day, it's either going to be the parent of your children, or somebody you shared quite a long time with, most times, and you just want to make sure that things are fair. And that's the reason that Jodeen mentioned the transparency. Disclosure is going to be part of the game plan in a sense, but there's always those who might try to play outside of the rules, and that's what we try to plan for, in terms of having access to your own independent funds. It does not mean that you're not going to be disclosing it sooner or later if the proceeding starts, or if there is any sort of negotiation going on. But you want to make sure that you have that access, so you're not stranded in a rainy day. And that's really the key concept that we try to educate people here. And I think, Jodeen, you wanted me to speak about something specific?
I'll get back to you, Golan. I'll go to Natalie next. But thank you. Yeah, that really does mesh well with Natalie's next topic, which is about closing joint accounts where possible. And the reasoning behind that is a lot of what Golan mentioned before. It's not necessarily to stash away money, but to ensure that you are not going to experience financial hardship during this transitional period. So I'll let you take it away, Natalie.
Thank you. So, in reference to closing joint accounts, I always say it's best to speak to counsel first before you close accounts. We may need a copy of your joint bank account statements to perform a reconciliation, for example, of post-separation adjustments. If you're claiming that somebody has not spent as much as you have, for example, on the mortgage or property taxes or home insurance, it may be important for us to review those transactions. And so it's necessary for us to have those statements accessible to us. Closing the accounts may mean that the bank is no longer able to provide us with a copy of those records. Also, we may need that evidence for specific dates as to balances or fair market values to calculate claims for equalization or property division. So again, please always just be prudent. Check with your lawyer first before you go ahead and close an account. It's better, again, to have permission than to seek forgiveness. Closing accounts may also pose a problem if there are pre-authorized payments set up. So for example, if you use your joint account to pay the mortgage or to pay a joint line of credit principal and interest payments, it can be very necessary for those accounts to stay open to avoid a default and any applicable interest charges or fees. It's best to negotiate an agreement about how ongoing expenses are going to be paid post-separation and what support will be paid, if any, between the parties before the accounts are closed. There may be exceptions, so again, it's best to check with your lawyer first. Take caution in withdrawing money from a joint account without the express written consent of opposing counsel or your former spouse. You may be held accountable for monies that you withdraw from the account. It's possible that litigants may seek a court order for reimbursement or that monies be redeposited to an account or to a joint trust account if the account has been closed. And there needs to be a determination about who's entitled to those funds. There are often many moving parts to family law matters and many issues at play. And it may be that you or your spouse are entitled to compensation above and beyond half of jointly held funds. The bottom line is that when in doubt, you should be asking a lawyer before you take steps to close an account. Feel free to jump in, Golan or Jodeen, if you have further comments on this issue.
Yeah, I'm listening attentively because it's all important, and I hope the audience is grasping, comprehending the importance of it. I think I can jump into I think there's a question that came from the audience,
Yes.
and
Yeah.
Jodeen, you want to introduce that?
Yeah, let's address this first question. So the question is, can you claim financial hardship if you're still living the same lifestyle, i.e., own the same assets, or will you need to sell your assets before claiming financial hardship?
So I think the easier way to explain that it goes directly to the point of having access to funds. You can live in a mansion and have nothing to eat. So
True.
what good does that do if you are not able to buy groceries, but you're living in a mansion that is a few $1 million worth? No, there is no expectation that you would be encroaching on a capital assets before you can claim and say, listen, right now there's a need to meet certain needs, right? There's certain needs that need to be met with finances, and that's where you measure the financial hardship when you don't have that ability uh, to meet these needs because of this. If somebody's choking the joint account or draining it then somehow, and or you have no access to credit cards, that what's going to cause you the financial hardship when you're not able to afford the basics. Um, so when the person thinking about, oh, I'm still living the same lifestyle, well, you cannot eat from the walls of your house or from the car that you're driving, maybe as luxurious as it may be. So one has to think about how am I going to ensure that I have access to funds um, to avoid that financial hardship. It's tied together. If you are in a situation where you don't have access to funds, but you do have assets, well, it's good for equalization maybe later down the road if you're married, but or other claims if it is a cohabitation situation. But in terms of supporting one another, the claim can be made right there and then, just because there's not enough to go around to allow both parties to be living not necessarily at the same lifestyle if it was luxurious or lavish, but we're talking about some more of the basics that we expecting everybody to be able to meet. I hope that answers the questions from the audience.
I think that's fair. I mean, I think it paints a really vivid image. You can't eat the car, you can't eat the walls on in the house. So, it's hardship is not really about the things you have, but how you're able to live. And so I think you answered that quite well. I don't know if you have anything to add to that, Natalie, or
Well, financial hardship or undue hardship is a very difficult claim to make out in general. And
mhm.
so selling assets will not necessarily assist you in making out that claim. So it's very important that, again, you speak to a lawyer before you take steps to dispose of or sell or encumber your assets, especially if you're doing so with a view to trying to prove that you don't have the financial means to pay support or to pay a fulsome equalization of property.
Thank you, Natalie. I think so. We've been talking about selling assets. Now I'm going to move on to avoiding making large purchases. So, Golan, if you could please speak on that and why that might be something you want to avoid during this transition period.
Well, again, it all ties up together to the same issue of, well, you want to claim financial hardship, you're not going to make a large financial decision in terms of purchasing
Mm-hmm.
something expensive when it's not a necessity. So it just ties together. The the idea of overspending in a sense, or spending lavishly at that point in time is first, it doesn't sound financially sound, and that's the reason I would say definitely speak to somebody before you're making that kind of decision. And it's also a relative concept. What is a large purchase? Somebody, an expensive pair of shoes may be a large expense. For another would be a luxury car. But what we try to avoid here is the optics of one taking a unreasonable expenditure and then asking for support. It doesn't go hand in hand when you're saying I need support because I need to have these purchases affordable and it's not there. So it's got to be a reasonable expenses. It's got to, you got to be mindful of the time of the relationship now that you're going through a transitional situation, and you have to budget, and you're going to have expenses going through many places that you not even expected. And don't forget, a lot of situations of domestic end up with also some criminal aspects and other things that can happen there, and these can drain you very quickly, because then you have to have somebody to look after your criminal matter at the same time as the family matter. And then, everything can kind of hit you together. And it goes directly to the budgeting that Natalie spoke earlier, that you have to look at these contingencies and the unforeseeable expenses. And that's the reason that it doesn't look good when you're making these large expenses with that kind of foreseeing what the family needs and what do I need in terms of moving forward and affording a litigation if it goes there, right? All of this just ties together.
Thank
That's
you,
my comment on
Golan.
that.
Yeah, I'm not sure if you want to expand, Natalie. I feel like Golan covered a lot there.
Just to add that transparency is very much applauded in Ontario family law. And so making large purchases during the course of your separation or divorce, and certainly during the resolution phase of the family law matter may not be prudent because you may be held accountable or be forced to pay back whatever monies you've used to make those purchases.
Right.
Yeah, and I'm sure the court doesn't look too kindly on frivolous spending either. So if that's what you're doing, you may need to reconsider. Natalie, you will the next topic you'll be speaking about is mediation as a means to reduce cost.
Well, and given Golan's mediation experience, I think he may well want to join in
Oh,
and
yes,
assist
as
me
you
with
should.
this
Yes.
topic.
I'll be
So
happy to share.
feel
I'll be
free.
happy to share my, my input to this. But go ahead, Natalie.
Amazing. So I would say in many cases, mediation can lead to cost-effective solutions. In some cases, however, though, it can be a waste of time and money, and you need to speak to your lawyer about your specific facts and circumstances of your case so that we can assess the best dispute resolution process available to you. We consider whether mediation is advisable, for example, where there's a power imbalance between the parties, where one or both parties are self-represented, where non-disclosure or a failure to provide fulsome disclosure or financial information is hampering progress in your case, or where people are engaged in having entrenched positions, where they're behaving in an evasive manner, stonewalling, and therefore making mediation simply unfruitful. Again, consult with your lawyer to ascertain the most effective dispute resolution process, and they can explain to you why they're recommending a particular process to you, as well as estimated costs and other available options. Also ensure that you or your lawyer have fully researched the hourly rate of your mediator, their area of expertise, and their experience level. Not all mediators are on the same playing field, and therefore I would suggest it's a good idea to have your lawyer help you select an appropriate mediator based on the issues at play in your matter. More often than not, the costs of mediation are shared equally between the parties, but in some cases, it may be necessary for participants to pay in proportion to their respective incomes, or for one participant to pay the upfront costs fully, conditional upon them being credited against the final settlement or determination of the matter. Golan, do you have
Yeah, if
anything
I
you'd
can
like to
jump in.
add?
I see two
Yeah.
things. Firstly, I thought you answered that because somebody
Yeah.
entered a question regarding when is mediation inappropriate, and Natalie just answered that. That's the reason for the a power imbalance
Yeah.
screening that we call
Mhm.
that we're doing ahead of time. So the few aspects that would determine appropriateness, let's call it that, is basically the power imbalance of the parties, seeing the dominant, the fact of whether or not they're being represented. They, takes a big makes a big difference in the in deciding whether, me as a mediator, whether I even take on a matter like that when one is represented and the other is not. Another situation would be family violence that would basically suggest that one side is a more coerced or likely to give in to any demands, or there's something that's going on in the background that may affect a fair resolution. Other aspects could be, Natalie mentioned that, you have to see how far apart the people are. Now, I'm not saying that in mediation, some mediators are able to bridge any gap, right? It could be that one is asking for the stars and the moon, and the other is all the way the other side of the ocean. And the point is that a mediator is able to maybe shed some light on realistic expectations, and then especially if both parties are represented with lawyers, there's a lot that can be achieved. If the other if the other lawyers of the parties are content that mediation is appropriate, then it's like you gotta be deferring to their idea of they know the case probably better than you, the mediator, to suggest that there is room there to negotiate and to maybe get everybody to agree to something they can live with. It means that everybody may have to, normally everybody will have to compromise in order to be to feel that they're at least got their way in the mediation. As long as everybody's missing something and losing something, then it feels fair. But so that's the main factors to see. Firstly, what are the issues? How deep are the gaps between them? The representation, the personalities, all of that will affect the decision of a mediator whether or not to take on the case. The relationship with counsel that represents the parties is a big factor as well. It can affect, if I know the counsel that represents the parties, I feel comfortable that there's somebody to talk to and reason with, then it may persuade me, even if the situation is seem to be unresolvable. But in other matters, when you know that one is very positional in their negotiation tactics, then it may not work. But mediation overall, I find that in most cases do settle in mediation. Yes, there are the exceptions. There are, I didn't do the statistics, but my feel of doing so many of them is that I remember most times that it ends up with a separation agreement that the parties either take out to their respective lawyers or already have lawyers and review it to conclude the matter. So it's definitely a very effective tool as an alternative dispute resolution. And what Natalie is doing, I do that, some of them too, the collaborative aspect of things, which is kind of a more than it's not a mediation because there's no third party kind of suggesting things to the others, but rather a more of a teamwork that brings to the table suggestions and getting the input from the parties themselves to resolve their own thing in a sense, which is way better because when the parties come up with their resolution, it's something that they're going to live with and they know that it's fair and balanced. And I think that is in a sense an advantage over a classic mediation when you have a third party that kind of make the suggestions or the resolution that it brings to the table with a hope that both parties would buy into them. So that's my take on mediation. I would always, I normally recommend that, especially if the funds are available and the parties can cut short their litigation costs. It's always a good something to consider.
Of course, yes. Definitely something to consider. I think what we've gathered from what both you, Golan, and Natalie have said is that it's not necessarily going to be the thing that's going to fix it. Mediation is not necessarily going to be the thing that's going to fix it. The parties have to come in with the right mindset, and they have to be in the right position, whether, a level of sophistication and whether there's family violence involved. Like, it's not going to be for every situation, and therefore, as Natalie said, this is something that you may need to talk to your lawyer about to see if this option is good for you. And so our next topic, sorry, there's no smooth way of going into this one. I didn't come up with anything. But Golan, this is on you. Okay, let's talk about building an emergency fund.
Well, we practically spoke about that because
Yes,
the emergency fund is access to money. That's what it is.
yes.
Making sure that you have access to funds that you may need, whether if you are subject to violence and you need to take off and make sure that you have shelter or anything of that sort, you want to make sure that you have the money available to pay for hotel room, for gas, for transportation, whatever that may entail. Other situation would be, first and last month rent. If you decided, time to physically separate and you need to be placed somewhere. Like we spoke about having an accessible line of credit. We spoke about, maybe you have to tap into family members' help, but or at least have them prepared, or at least kind of have them on the same page that this might happen, or so on. Um, but sometimes it strikes you when you're not prepared, or you're not expecting it to happen, and that's the reason that rather than having an account with money sitting in it or whatnot, you want to have access. If you have few credit cards with some limit on it, you want to make sure that they're in good standing and everything is available if need be, because everything today can be practically paid with electronic funds. And yeah, but it's always good to have few dollars at hand to for the little things.
Yeah.
But that should be something that you just as you go, you may want to have like Jodeen indicated at the beginning. If you have your own account and you have some money there, nothing's wrong with that. It's going to be disclosed as part of the process, but at least you'll have access to the funds without being conditional on somebody's approving it or not approving it and so on. So you kind of your own boss in that respect, and you're able to use it as needed. So that's the idea of the emergency or rainy day in any event, right?
Yeah. Thank you, Golan. And Natalie, I believe you kind of touched on this next topic a bit earlier. Is there any additional thoughts that you have on seeking professional financial advice?
And there are some additional things that I would add. I know I already canvassed some financial professionals that you may want to seek advice from. Depending on your goals, your interests, and your circumstances, it may be prudent to consult with a financial planner, as I said earlier, an accountant, a certified divorce financial analyst, a mortgage broker, an investment advisor, a certified business valuator, or an actuary. It's never too early, as I said before, to seek out advice, and I would suggest you do so even if you're planning on partnering. I would suggest it's helpful, or planning to pay for your own schooling, for example. So long before the separation or the divorce actually ensues, it's a good idea to start planning for that rainy day, as Golan said. A neutral financial professional can assist you in identifying tax credits, benefits, and deductions that you may qualify for post-separation. For example, you may be eligible to qualify for claiming legal fees that you've incurred in your family law matter as a tax deduction. So you'll want to consult with your accountant to verify. And if you do qualify, ask your family law counsel to provide you with a letter confirming the amount of legal fees that you paid that may be eligible for a tax deduction, because that may save you a lot of money. You or your family members may also qualify for grants, bursaries, financial aid, or subsidies that help you to afford expenses such as education fees, or childcare costs. Researching these possible monetary incentives can help stretch your after-tax dollars further than you think possible. Seek out a good investment advisor who can help you to invest monies derived from the resolution of your family law matter. They can assist you with saving for retirement or your children's post-secondary education, financial forecasting, generating interest, investment, and other income, tax-efficient investment strategies, budgeting to plan for the purchase of a home, or other major life events such as a future wedding, and or a funeral. Not all financial professionals charge for their services, and those who do charge for services rendered can vary significantly in terms of their hourly rates or their fee structure. Take the time to interview several professionals to ensure that you find the right fit for you and your legal counsel should be able to assist you.
Thank you, Natalie. And Golan, your next topic is thinking about future financial goals, which, very well marries with what Natalie just spoke about. Are there any additional points that you want to make about future financial goals?
So what we can, I mean, this is a very kind of broad topic, but because it depends really on where you are at life, right? What
Yes.
age are you in? Are you 60 or 70? Are you at the end of your career, or are you, in your 30s, where you should be looking at how to become self-sufficient and maybe upgrade your skill, go to school, as Natalie indicated. But when you're 65 or 70, the situation is different. So you may be looking more at investment planning because you may have equalization coming to you and you want to know how is that money going to last me for the rest of my life. So I have to look into pension, I have to look into the investments, the RRSPs that has been accumulated and maybe shared. So the planning at the end of the day is to be self-sufficient either, and it's not always self-sufficiency that we're looking at because again, it depends on where you are, what age you are, and what did you do in terms of the family structure when you were together. So if you were just not just there, but a homemaker and looking after the household and the kids, and you let go of your major years of advancing your career, it's not necessarily self-sufficiency, but rather how do I manage the cash flow that I will receive, maybe by way of spousal support, maybe the equalization that I receive, and how do I budget that going forward? So all of that has to, again, tie up with financial planning, budgeting, knowing your expenses, whether you have some medical expenses going on, or whether you still want to upgrade your skill regardless of your age, and you want to do something still that will keep you occupied and busy during your retirement. So, your resources can vary from, spousal income to pension income, CPP, your investment income, maybe rental income, maybe other passive incomes that you may have. All of these have to be looked at in a more comprehensive plan to see that you have the cash flow to meet your future budget. It might not be the same as when you were living together, as Natalie mentioned earlier. You're splitting the pie now, and it may not be the same, and you may not be at the same level necessarily. Again, it depending on how wealthy was that family. If that, it might not change a thing. Everything might flow just the same, and you won't feel the difference. But if it's kind of, on a tighter budget,
Yeah.
and it's, you have to look at a range of maybe 20 or 30 years to go, then you have to look at it more carefully and make sure that you have the funds and the skills to make sure that if the funds are not there, you're able to look after yourself, or if the funds are there, then you're able to comfortably budget for the rest of the time that you're going to be kicking around. That's the main idea, right?
Yeah. The rest of your time you're gonna be kicking around. Yeah. Yeah. There is a question, and I think I will pose it as a more general question about how RRSPs might be treated, during this process, during the transition process. I don't know if you, either of you have any thoughts about that.
I can answer that. So the idea of RRSP is we normally use that a vehicle to equalize the assets of married couples, where there is an entitlement for equalization, and we use that as one of the vehicles to equalize the assets. What it means is that prior to a cashing the RRSP, which means there's going to be tax implications on the owner of the RRSP, we do a spousal transfer such that each party that receives the funds is now going to be subject to his own or her own tax level according to the income tax or whatever the relevant income bracket that she's at or he's at. So the use of RRSP is very useful not only during your working life, where you can deduct all of these funds from your income and receive and pay tax only on your income without after the contribution to the RRSP. That means that it could be if on 100,000 I think you can contribute today something in the ballpark of 25 or 26,000. Please check that with your accountant, but I think it's 18%, if I'm not mistaken. But let's assume for just discussion purposes that it's about $20,000 that you can put away every year. You can imagine that instead of paying tax on 100,000, you're paying tax on 80,000 because you put away 20,000 in RRSP. At the end of the road, when equalization is necessary, and we're looking at the at the egg nest that has been built up, then we can, and there's money that's owed from one party to the other, then that's one of the aspects where we can implement the payment from that RRSP, from that nest egg. And we move that over to the other spouse. There's some obviously bureaucracies and bank forms that you have to complete, but well, that's the part of the pain that goes with it. And but it is an effective tool to have. Now, don't forget that after a certain age, then the RRSP turns into lira, and there must be a draw to be completed every year. So, assuming that you are in an age where the RRSP is still alive and you can still contribute to it, and there's still that spousal RRSP transfer that's available, then yes, it is a good way to equalize the assets.
Oh, please, yes.
And I would just add to that, I agree with everything my friend said, but if people are looking to withdraw from their RRSP to use that money to pay for legal fees, I would caution them in doing so. It's not that they can't, it's that there may be other more tax efficient ways to pay for your legal fees rather than withdrawing from your RRSP, because as Golan said, that will be income for tax purposes. And there are other reasons why you may not want to overinflate your income, particularly if there are support issues at play. So consult with your counsel first.
Yeah.
That's always a good
Yes.
idea.
That's the key. Consult with your counsel first. Yeah, as you can tell, there are many different ways that your situation can play out, which is why in these sessions, this is legal education and not legal advice, because to give legal advice, we would have to know the specifics of your situation. So I had one more thing to say about avoiding emotional spending, but I feel like it's been very well covered throughout. I will, I guess, say that at the end of the day, divorce isn't just about ending something. You're trying to build your future, so make wise choices when you're spending, and also because during the process of separation and divorce, financial disclosure will always be, it's an ongoing obligation that you have. Just bear in mind that, some things don't get hidden. So yeah, it's just, it's the nature of family law. Transparency and disclosure is important. So yeah, don't try not to spend on things that may impact your settlement or lead you into legal trouble in the future. And that's where I will end it. This was a great conversation. As you can tell, we could dive deeper and deeper into just about any one of these topics. And thank you to so much for your contributions and for your responses to the questions that the audience had. I was informed. I was very educated during this session. So thank you. I'm sure they have been as well. So thanks again for tuning into Family Law Now. Following this session, there will be a brief survey which will appear, allowing you to share your comments and suggestions for future topics that you'd like us to explore. Your feedback is greatly appreciated. We always want to get better, so hearing from you would be great. Thank you in advance. So book now to get to take advantage of the opportunity that I mentioned earlier for the complimentary consultation with one of our lawyers. If you're lucky, maybe it's Natalie. I'm just kidding. They're all great. They're all great.
Thank you. You're sweet.
Please contact our intake team at intake@russellalexander.com and provide the code MARS 2025. I don't know. But that's the code, MARS 2025, to schedule your appointment. So registration is open now for our next event, which will be want to keep the house in the divorce? Maybe try this. Interesting. Yeah, tune in. We're happy to have you. Thanks for staying with us, and thank you both again. Have
Thank
a
you,
good rest of
Thank you
your
to
Jodeen.
both of
evening.
you.
Thank you,
Bye now.
Natalie. It was nice seeing you again.
You
Have a
too,
good one.
Golan, as always. Thank you, Jodeen.